Well, Renee, welcome. Thank you for attending today's Ask the Attorney. I am Mark Seib, as Bonnie mentioned. I'm the president of Ganek PC. I also have the pleasure of being the lead relationship manager with our relationship with PalmerHouse. I have been involved with PalmerHouse since 2006, back when it was a company being run out of Kevin Palmer and Tom Ellicott's home in Virginia Highland. Back then, there were about 30 part-time agents, and so to see the growth of PalmerHouse between then and now has been pretty amazing. You've got over 2,000 agents in Georgia, so as PalmerHouse has grown, our firm Ganek PC has grown with you guys. So I've got a couple slides I'd like to share real quick, if you don't mind. So the first
Sure.
one should be up on the screen now. So this is a map that shows the locations of Ganek. I'm based out of our Midtown office, but we have attorneys who close throughout our entire network of offices. So I'll start just kind of down the list. Letter A is Midtown, where I'm located. We actually moved our office not too long ago. In mid-February, we were over on the west side of Midtown, and we moved back to the original Midtown. So we're right on Peachtree, kind of diagonal across from Colony Square. So we're up on the fourth floor of a building that's pretty well known, and 1100 Peachtree has a couple big law firms as tenants. And one thing about it, the parking, one of the reasons I picked the building was very easy access from the interstate, from Peachtree into the parking deck and up to our suite. And of course, we do validate. So I also manage our Tucker location, which is letter E. There's a fairly large team of PalmerHouse agents that are also based out there, and that's Pat Soltis leads the team, the Smoke Rise agents, and so I've been doing business with them for a few years now, and decided it would be worthwhile for Ganek to have a location out in the same office complex. So we've had that, like I said, coming up on probably 2 years now. But I skipped over letter B, our Ponce Highland location. The managing attorney out there is Mimi McCain. Letter C is our Kirkwood location. So we, in March of this year, merged with another law firm. The managing attorney is Marnoush Sadat, and her firm was Blue Ink Title. So we merged with them, began closings under the Ganek name in April of this year, and she's a huge success, and we're very proud of that merger. Letter E, Tucker, I already mentioned. Letter F is our perimeter location. My partner Renee Dillon manages that office. Letter G, Marietta, is kind of a work in progress. So we have rented an office space within the PalmerHouse Marietta office, Marietta location, and are in the process of getting our furniture in there and all the software we need. So we'll be operational there very soon. Letter H, in Kennesaw. We have had a Kennesaw presence for a long time, but recently expanded our footprint out there, and our accounting and HR and post-closing departments are out there, but we also have a closing operation. So for agents who haven't been there yet, we welcome them to come see us in Kennesaw. Letter I is Alpharetta. We've had for a while. Gwinnett is managed by my partner, Harry Minsk. PalmerHouse is just down the hall, and Angie Meza-Smith works often in that location. So we have a lot of sort of joint events between Ganek and PalmerHouse out there. And then one of our newer locations is all the way out in Brazelton. So the nice thing about working with Ganek, one of many things, is you can work with whichever attorney and close in whichever location that you prefer. So I'll cover that a little bit more when we get to the materials. The next slide I'd like to show you is got that same map there in the middle. Ganek has been around since 1978. So we're what, 44 years in. And these are some of the attorneys that work very closely in the PalmerHouse account, but it's not all of us. So we are up to 11 locations and 12 attorneys, but some of the attorneys that are more heavily involved with the PalmerHouse relationship are shown here on the screen. And then our last slide, once again, there's that map, but listing out for you, the ABCs of closing, always be closing with Ganek, and our 11 locations, 50 plus staff members. Really, PalmerHouse is a firm-wide account, and so every employee of the firm, every attorney in the firm really is involved with the PalmerHouse relationship. So it's one of the most important relationships that we have. So we're very, very proud of that. So I'm going to stop my share and just go back to the materials. So I developed a list of some of the frequently asked questions. I'm just going to kind of run through those. And so if any of you have any questions for me, please feel free to use the chat function. And I'll be monitoring that. And if I see a question, I may pause and go ahead and answer the question if it relates to the frequently asked question that I'm covering at that particular moment, or I might save it. And of course, I'll take some questions at the end. And if you have questions that are unrelated to what I'm presenting, I'm happy to answer those as well if we have some time. So my first frequently asked question is the following: my seller is getting divorced, but his wife was never on title to the property. Does his wife have to be involved in the sale? So even though the wife is not on title, when a divorce is pending, there's something called the standing order that most or all of the clerks of Superior Court enter. The Superior Court enters in that case. And basically that prevents either party to a divorce from conveying title to any property that might be part of what we call the marital estate. So even though the wife wasn't on title, that alone does not allow us to deal just with the husband. We would run title, and our title examiner, one of the things they're looking for is, are there any pending lawsuits that affect the owner of the property? And a divorce, of course, would be one of those. And so part of our title report, we would get a copy of the divorce action. And one of the things that the examiner would be looking for is, do we have a settlement agreement in that case? And if we do, and if that's been accepted by the court and recorded, then our answer is going to lie in the settlement agreement itself. And so often we're dealing with what's called the marital property. We'll look at that. They may have investment property too, but in a good, well-drafted settlement agreement in a divorce, all of the real estate that the parties own, either together or independently. So we could have maybe the marital residence title is held by both the husband and the wife. And then we could have two investment properties, one in the wife's name, one in the husband's name. And we would need for, whichever property we're closing would need to be covered in that settlement agreement. And we'd read the agreement and we would hopefully find what we're looking for, which is, for example, all of the proceeds shall be paid to the husband at the time of the sale. Or we could have something like, husband is entitled to live in the property and shall market the property within 6 weeks of the recording of the settlement agreement. And it might have some, terms that, spell out, the minimum that the property has to be listed for, what sort of expenses get paid out of the sale. And ultimately, maybe there's going to be a distribution should be made, in this case, to the wife, of $20,000 that is almost like a payoff that we would plug into the settlement statement and just show just the same as if we were paying off a mortgage or a property tax bill or something like that. Now, some divorce attorneys don't think like a real estate lawyer, and they'll be a little bit vague in their language. And so sometimes we can get, it can be a little challenging figuring out, like, how much does it go to each party? Something like, remaining proceeds to be split 50-50. I mean, that's fairly simple. But in these scenarios, we would often want to email the wife, or maybe the attorney who represented the wife in the divorce, with a draft settlement statement, and we would show a line item of the proceeds that would be payable to the wife, and that way we can get some approval. And we're really trying to protect the buyer and the lender, if there is one, ultimately, to make sure that after we close, that in my example, the wife doesn't later file a lawsuit saying that the proceeds that were dispersed at closing were the incorrect amounts, and wanting to try and revisit somehow the sale of the property. So we really prefer to get that sign off from the spouse. And if the divorce is still pending and we don't have a divorce agreement, then it's going to be really challenging for us to close. We've actually had a few of those lately, where we've had to engage a dialogue with the other party in the divorce, or sometimes with both attorneys, both the attorney representing each spouse, and sometimes we even have to get our title insurance company underwriter involved, so that we have the underwriter's blessing. We recently closed one where it was just the wife who was entitled. We had a divorce agreement that got filed in the case just a couple of days before, but they were still not really final in terms of how much went to each party. And so it authorized the sale, but didn't completely resolve how much money went to each party. And so we were able to disperse all of the proceeds to one of the attorneys, in this case, the attorney representing the wife. And fortunately, the wife wasn't about to close on another property, so it kind of all worked out. But all of this is, kind of leads to a piece of general advice that I always offer agents, which is make sure that your buyer or seller are responsive to us. When we, most importantly on the seller side, we send out a request for seller information form, and the sooner we get that back, the sooner we can start dealing with issues which we may not know about in the very beginning when we open our file. And one of the questions that we ask our seller or sellers is there an active divorce, a pending case? And the sooner we know about that, the sooner we can start working on it and hopefully get the parties to at least enter some form of settlement as relates to the property that we're trying to close, and an agreement as to how the proceeds are to be divided, or are we going to be able to wire that money to one of the attorneys representing a party to the divorce. So the sooner we know about that, the better. All right, so any questions on that? If you have them, again, please feel free to put them in the chat function. I'll move on to the next frequently asked question that I've got, which is the following. Title to the seller's property is held in an LLC, but he would, and I emphasize the word he, would like his proceeds sent to his personal bank account since he is the sole member. Can we do that? And this answer is always a bit disappointing, but the answer is no. We cannot do that. That's a title insurance company underwriting rule number one. And the law firm, we are acting as an agent for the title insurance company. So I'm just going to use, for my example, Chicago Title. Chicago has this rule, and we cannot issue a title insurance policy in violation of the rule. And so then the parties usually ask, well, why not? So in this case, our example is that the agent is saying that the person that they're working with, the individual, is supposedly the sole member of the company. And we may even have documents that tell us that that is the case. But what we have to worry about is really a kind of a form of fraud, which is, what if that person who has represented to himself, to the agent, and then later to the law firm, to be the sole member of that company, turns out to not be the sole member? So this leads it into Georgia law is a little bit deficient in terms of, you can create an LLC online. It's a one-page document. You answer a few questions with the Secretary of State. You submit that application, and ultimately what gets issued to you are articles of organization, which is the evidence that the LLC has been formed. And there are two requirements in Georgia for that LLC to be formed. A few requirements, but in terms of names of persons who are involved with that LLC, you have to name someone who acted as the organizer. So that's the person who created the LLC. And a lot of times, again, it's the online filing, which is when you print it out, it's a one-page document, the articles of organization. And then you also have to name a registered agent. So the organizer, again, is just the person, or sometimes it's the attorney, who created the LLC. And then the registered agent is going to be either a company, or sometimes often it's also an attorney who will act as the registered agent, who is the person who will, accept process on the form on behalf of the LLC. But what Georgia does not require is that the members, one or more, be disclosed in the articles of organization. And that's really creates some real headaches for us on the law firm level, and for underwriting for the title insurance, because we don't often have an easy way of figuring out who we're dealing with. So one of the questions here, again, referring back to our request for seller information form, we're going to ask, how is title held? And if the answer is an LLC, we're going to request the organizational documents for that company. Now, two of them are available online. We can go to the Secretary of State and we can confirm that the LLC is in good standing, that it still exists, it hasn't been administratively dissolved. We can print out the articles of organization, which is, again, the document that evidences that the LLC exists in Georgia. But the third document that we need, the operating agreement, that is not a public record. And so we're relying on the seller to provide us with a document, and that the document that we receive, the operating agreement, is the most current draft of the operating agreement. So let's say we had an LLC which was formed, and even if I found in the articles of organization, there's a section where you can put optional comments. That's usually left NA, not applicable. But sometimes I'll see an LLC formed online, and it'll tell me the sole member of the company is, and it will provide the name. And I'll look at that name and I'll compare it with the name that I see on the signature line of the contract. And if the name matches and that's who filled out my seller information form, I'm starting to feel pretty good about that. But that's not necessarily, I can't necessarily believe that I've gotten all the information I need. So I'll ask for the operating agreement. Have there been any amendments to the articles of organization? So they could have had a private document, which would be a transfer of membership interest. Now, technically, you should file articles of amendment with the Secretary of State, but not every company does that. And we could have had originally one member who later decided to add two business partners. So now we've got three members, but we're not, and this is something that we wouldn't know, because if the one person who wants to receive the proceeds from the sale is trying to, outmaneuver his two business partners, if I disperse the money directly to that one person individually, I could later find out that there were two other members of that company. The company was entitled to the property. The company is who sold the property, and so the proceeds were supposed to go to the company. And maybe in that transfer of membership interest, where we added the two additional members, they were each supposed to get a third of the proceeds. So that's the reason behind that rule. And again, it's very disappointing. So again, if I get my seller information sheet back, we have a disclosure in there, if people bother to read our entire document, that instructs them that we will have to disperse the proceeds to the company. And if they don't have a checking account, then they'll need to open one. And so we're ultimately, again, trying to protect the buyer, the buyer's lender, if the transaction's financed, and really in a way the agents too, because once a lawsuit gets filed, then a lot of times everybody related to that transaction gets named as a defendant. And you don't want to be hauled into court or have PalmerHouse hauled into court. So there's reasons behind all of the rules that we have. So let me go back to the chat. We did have a question. What kind of so we're back to a question related to divorce. And I think all of you have access to the chat. So so Monet asked, I have never had a divorce issue yet. What kind of documents do I need to ask for up front? Also, if the divorce decree is not on title, do they need to sign maybe you meant the settlement agreement as well? So in my earlier scenario, the wife was not on title, the husband was. So only the husband would sign the signature line of the settlement agreement. The wife also would not be required to sign the purchase and sale agreement. So one of the question that you just want to ask is, and maybe hopefully are there any special circumstances related to the sale of this property that I should know about? And if your seller is going to be forthcoming, then they might mention to you, oh yeah, I'm currently in the middle of a divorce from my soon-to-be ex-wife. So just knowing that, and when you send over your contract to us, just let us know that that special circumstance exists. But really what you can do is just make sure when we open a file that the seller completes our seller information request form as quickly as possible. And just try and encourage them to read the form carefully and answer the questions carefully. And if they don't know how to answer a question, then they should just reach out to us. One of our closing coordinators would be happy to help with that. So Monet, you amended so the listing agreement, again, in my scenario, the husband would be the only one who would have to sign the listing agreement because the husband's the only one on title. But again, the sooner we know about issues, the sooner we can start working on them.
Okay, thank you.
Okay, sure. So on to frequently asked question number 3. My client closed on his house with your firm a month ago, and he would like to add his parents to title. What would you charge for that service? So let me give you the fee that we charge. So at our firm, if we're given a request such as this at the closing table, we do not charge for the preparation of the deed to add an additional party to title. We do, of course, charge for the recording costs because that is a hard expense that we have, and that cost is, dictated by the Georgia Code. So it's $25 for recording the document, and then we use a service to e-record our documents for us. And so that e-recording fee is an additional $4.75. So in a perfect world, let's say that the contract comes over and it is in the wife's name. So we're going to close, and let's say it's financed. So we'll close the transaction where seller conveys title to the buyer, to the wife. We then close the loan, which is in the wife's name only. And we are told ahead of time that the wife would like to add her husband to title at closing. That's great because we'll prepare the deed adding the husband to title ahead of time. We will go ahead and collect on an early draft of the settlement statement, the recording cost and the e-recording fee. So that makes it real easy for us. Now, let's say instead we're at the table and I'm sitting there, in the middle of the closing, and the wife, maybe we're all the way at the end, and I present to the wife a copy of the deed that the seller has signed, and I show, here's a copy, and we're going to get this recorded, and then in about 7 to 10 business days, we'll email you the recorded deed. And she looks and she says, "Oh, wait, this is in my name only. This is supposed to be in my husband's name also." Well, that can be fixed. It's just a little more challenging for us because we already have a wire in from the buyer, and I'll say, "Well, do you have your checkbook with you?" And especially if the buyer's a millennial, they don't have checkbooks. So now we're needing a recording fee, and there's no way, we can't take it out of the wire because the wire was for exactly the amount we needed. And the buyer doesn't have their checkbook. So I'll go ahead and let them sign that document, and then I'll say, we're going to hold this and we will record it as soon as you mail us a check for, and they'll say, "Well, can I Venmo you?" Well, we're a law firm. We're not set up for Venmo or any other form of, electronic payment such as that. I mean, we could take an ACH for that payment. We have a portal online, but then we have to wait maybe as long as 15 business days for that ACH transfer to be final. So ideally, we know about the one spouse wanting to add the other spouse to title at closing ahead of time. There's also a way that this can be structured that the loan, as long as the lender would allow for it, where the loan could close and the loan would be made in my scenario to the wife. So only the wife would be signing the note. But title would be held initially by both the husband and the wife. And so then the husband would have to attend closing and would also have to sign our mortgage document. It's called a security deed in Georgia, and any documents related to title. And some lenders have a few more that they'll want the spouse to sign as well. And so that way we don't have to add, in my scenario, the husband to title, because the husband was entitled from the very beginning, but not on the loan. So it's a lender, again, the lender needs to know about that ahead of time, and they can potentially structure their loan that way so we don't have to have 2 warranty deeds recorded. Now, in my frequently asked question, the request was to add parents to title. Now, that is not something that we can do, at least not without written permission from the lender. And that's because there is in the security deed signed at closing, there is a prohibition against transferring title to any third party without the lender's express permission. But there's an exception to that rule. A party can transfer title to their spouse or to their children or to a trust as long as it's for the benefit of the borrower or their spouse or their children or some combination thereof. And if you think about that, the reason for that is because it has to do with inheritance. So you can pass title, in a downward sense, but you cannot add a fiance. You cannot add a domestic partner that is not your spouse. You cannot add parents. You cannot add a sibling. You cannot add a roommate. None of those things can happen without the lender's written permission. And a lot of times people will say, "Oh, well, my loan officer says it's fine." I cannot take instructions from a loan officer. I mean, even the best loan officer does not in that company have the authority to make that decision. I need that email to come from an underwriter, someone in the closing department, an officer of the company, a VP, a president. And that's usually the stumbling block that we have, that we can't get someone to authorize us to add, in this case, the parent to title. So we're prohibited from doing that. All right, so next one. We are purchasing a property all cash, set to close in 12 days. can we use the Ganek ACH option on our website for submitting earnest money? So the problem with that is, I touched on that just a moment ago. We do have a portal on our website. We use a service called Forte, Forte. Some of y'all might be familiar with that. Some brokerages use it as well. And it is an ACH transfer. So it's easier for people to move money. It's faster. It sometimes avoids a fee or reduces a fee. But the downside is that ACHs are not a final deposit into my law firm's escrow account for a period of days. And that period is 10 to 15 banking days. So in our scenario, we're trying to close in 12 days, and the ACH portal is just not going to work. So we would, in that scenario, send out a link to Certified is the service that we use for providing our wiring instructions in a secure format. And we would need the client to wire their earnest money to us. There's various ways that we can get the earnest money. I mean, we can also take a personal check, but again, just like an ACH, we have to have enough time for that check to clear our account. We can take the ACH as long as our closing date is far enough out. But in more cases than in most scenarios where we're acting as a holder, we do end up getting the earnest money wired into our account. All right, next one, number 5. May I act as power of attorney for my client? So I find the terminology is often mixed up here. So the document that the person who is granting authority for someone else to sign, the document is called a power of attorney. And then we use the term, the person who is appointed to act on behalf of the party who is the party to our transaction. The party acting on their behalf is called the attorney in fact, or sometimes it's abbreviated AIF. So PalmerHouse has a policy that their agents are not allowed to act on behalf of, they're not allowed to be the attorney in fact on behalf of the buyer or the seller. So we would much prefer that you, your company policy requires it, and the law firm would also prefer, even if your company didn't have the policy that it does, we would still prefer that an unrelated party sign on behalf. So an unrelated party to our transaction, I should clarify. So, a good example would be, a spouse signing on, let's say it's, again, the wife is on title, but the wife's going to be out of town for business. Can the husband come to closing and sign on her behalf? Perfect solution. Or a parent will sometimes sign for a child, or a child for a parent, a close friend. Those are all better because the person signing does not have any financial interest in the transaction. They have nothing to gain, and so they're going to hopefully act in the best interest of the party that they're representing at the closing table. All right, so number 6, my seller is acting on behalf of an estate. How should I set up the signature lines on the contract? Now, I will tell you that even the best agents, the most experienced agents, manage to sometimes get this wrong. So the most important thing for the law firm to know, and ultimately title to know, is that we are dealing with an estate, that the last owner of the property has died, and then there's various solutions to how we are able to ultimately close on the sale of the property. So in our example, the question was, my seller is acting on behalf of an estate. So the first question I would want to know is, how is it that they are acting on behalf of the estate? What gives that person that, let's say you're the listing agent, you're representing someone who purports to have the right to sell the property. So the first question is, how is it that they have that authority? So some of the things that you could ask them for is, one, are you the executor of the estate? So an executor is a person who has been named, typically, they are named as an executor in the will that was left behind by the deceased person. So the most basic question is, was there a will? And then the second question, has the will been probated? And a third question, which we would like to know, is, has the will been probated in the same county where the property is located? So when we get a contract over, in a perfect world, it would say, John Smith, comma, as executor of the estate of Jimmy Smith. And, maybe in our scenario, John is the son of Jimmy. So our signature line reading like that, we know from the get-go that we have an estate and we have an executor, which is a good thing because it's going to be a little bit easier to clear that title. Now, let's say that there was no will and Jimmy died and he had no will and he had no spouse and he had no children and his parents are already dead. So who are we going to then be looking to? So in Georgia, we have something, if you die without a will, that's called dying intestate. In the Georgia code, there's a hierarchy of who stands to inherit on behalf of that dead person. So again, Jimmy's who died, and Jimmy has no spouse, no children. That's the first category. So then we look to the second category. Did Jimmy have parents still living? Nope, both mom and dad are already deceased. So then the next category is siblings. And let's say Jimmy had 8 siblings. So managing that estate is going to be rather challenging unless we have someone appointed by the probate court as the administrator. So one of the siblings could petition the probate court to be appointed administrator, and then that person is going to have to reach out to all of the other 7 siblings and get them each to sign a document for the probate court agreeing that that sibling, the one who's sort of taking the lead, is going to be appointed as the administrator. That would be step 1. Step 2 is we want to make sure that the administrator has the authority to sell the property when we get to the closing table. And so we want the administrator to be appointed with power of sale. And that's also something that the administrator has to request from the probate court. And in my scenario, all of the siblings have to agree to that. And then the last scenario is no one's been appointed as the executor because there was no will. The siblings can't agree on one of them who is going to serve as the administrator of the estate. So now we're dealing with all of those heirs, all of what we call heirs at law, and we're going to have all of them participate in our closing. And I literally have had this happen where I did the seller side of the closing, and we had I think I had siblings and even cousins and maybe an aunt and uncle. We had to establish who all of those heirs at law were and who held which percentage interest. It was really messy. I mean, we got it done, but it was a lot more work and complicated. We had to have, I literally had every seat on the seller side of the table and some pulled in from another conference room. So we had enough seating for everybody, and we just went down the row and everybody signed my deed one at a time. So we'd rather avoid that problem. It makes for a very messy closing for everybody involved. So the signature line of the contract, ideally it's a person's name as executor or as administrator of the estate of. But even if all you do is just say the estate of, then that is a clue for us. When we open our file, we know when we order title from our examiner, we know from the beginning that we're dealing with an estate, and our examiner will know that not only do they have to search the real estate records at the county, but they also have to search the probate records at the county. And so then that other question I asked is, like, in which county did the decedent pass away? Is that the same county where the property is located? So let's say Jimmy owned property in Fulton County, but at the end of his life, he was living in a nursing home in Gwinnett. So when he dies, his will is going to be probated in Gwinnett County because that's the place of his last residence. But our property is located in Fulton. So if you're able to get copies of the one of the documents that's issued when you have an estate with a will, is once the will is admitted to probate, something called letters testamentary are issued. And that, if we have a copy, we'll see, oh, the letters testamentary were issued by the Gwinnett County Probate Court, but we know from our contract that the property is located in Fulton. So we're going to have our examiner, their search will take place in two different counties, the real estate records in Fulton and the probate records in Gwinnett. And they're going to assemble all of that into one single report for us. But what often happens is we don't know that the seller is deceased. So our examiner runs title on the real estate in Fulton, and it comes back and title is vested in Jimmy, but our contract was signed by John. And then we find out later, oh, John is the son of Jimmy, and Jimmy's dead. Well, where did Jimmy have a will? So now here we are, a week or 10 days into our time frame of preparing for closing. We've lost all those days, and we're just now finding out that Jimmy maybe did have a will, which is good news, but the will has never been probated. So that's bad news, because now we have to get it probated in Gwinnett. We have to wait for the probate court to do their thing. So things are going to go off the rails at that point. We're going to get it back on the rails, but it's just going to be a lot more work, and we're going to have maybe some delays, likely some delays depending on the time frame of the closing. So the sooner we know information about an estate, the better. But again, if your client doesn't volunteer that, if you don't ask that, we're going to hopefully figure that out when we send out our request for seller information form and when we get the answers back. So number 7, my buyer is getting a mortgage but can't be here for the closing. What are her options? So one is the power of attorney, we already talked about. And since this transaction, we're talking about the buyer side and it's financed. So who do we have to also work with to make sure one of our scenarios is going to work? The lender. Most of the money is going to come from the lender, so the lender gets to set the rules. And we need the lender to give permission for the buyer to give a power of attorney to some third party. So let's go back to my earlier scenario. The wife is going to be on the loan. The husband is in Atlanta already. The wife is still in Arizona because she's packing up the old house and the kids are still in school, and we're not able to move just yet. But the husband's already in Atlanta because of maybe his job relocated him here. So the husband could come to closing and sign on behalf of the wife. So that's a scenario that usually most lenders are going to be perfectly happy with. And we'll prepare the power of attorney. The law firm will prepare that. We'll send that out for signature ahead of time, and we're good to go. So another scenario is what's called a buyer mail away. Now these are more complicated, but we're happy to do them. So what we'll do is we will set up, we'll get a notary, someone that's approved by the title insurance company that's underwriting our transaction. We actually use representatives from a title company in another state. A lot of them approve of a service called Bank Serve, where the notaries have been vetted and they've had to sort of pass a test in order to work to be on the approved list for the title company. So they are familiar with real estate closings and the loan documents. And then Ganek, we've also added an extra layer of protection to the transaction. We now zoom in to that signing ceremony so that we can supervise the execution of the most important documents, the settlement statement, the note, the mortgage document. Again, that's called a security deed here in Georgia. So we'll zoom in, be there for the first 15 to 30 minutes of the transaction, get through all the important stuff, and then we'll leave the rest of it with the notary in that state to get all the additional docs signed. the affidavit of occupancy, the compliance agreement. The notary can take care of all that stuff for us. But in that scenario, most lenders have a rule. They require the person signing in the other state to sign their documents on the date that they are dated. So today is Wednesday, October 5th. Let's say I have a mail away to a buyer who's getting a loan and the buyer's out in Arizona. The buyer would sign today with the notary. I would zoom in for the first part of the closing, and then the notary would scan all the docs back to us. We'd review, we'd make sure everything looked good. And then we would tell the notary, okay, go ahead and drop that in FedEx, and we'll look for those documents to arrive at our office tomorrow morning. So a lot of realtors think that we are going to be able to disperse on today's date, the 5th, but we cannot disperse our file until we are in possession of the original documents that are being shipped to us from Arizona. So we would sign everything on the 5th. Docs would be dated for the 5th. Our settlement statement would be dated for the 5th, but we would not be able to disperse until the 6th. So keep that in mind. And unfortunately, this creates some havoc, especially when the closing is set up for a Friday, but we're not going to be able to disperse until the next business day, which is Monday. So if your buyer is planning on moving over the weekend, the seller may not be comfortable with that because the closing is closed, what we call in escrow, until we disperse. So a better scenario would be to have the closing date on Thursday, and that way we get our docs, the originals, back on Friday and disperse on Friday. I see time's running short. I've got about 11 minutes left, so I'll try and speed through a couple more of these. The seller's agent and I can't get the buyer and seller to agree on a date and time for their closing. Do you have a solution for that? Yes, we do. We are happy to close the buyer and seller at different times, even on different days, even in different offices. So I've had closings where we close the seller on Tuesday in Tucker, and then we close the buyer on Friday in Midtown. So we're happy. We have all of our attorneys. We're there to help each other out. Back to our map. Our map's available on the website. You can see the list of all the offices. So just be in communication with us and let us know that those special circumstances exist, and our closing coordinators will work with you to come up with a scenario where we don't have to have all the people at the table at the same time. I mean, I like those closings where everybody's together because it's kind of, it's a fun time, usually a happy time for everybody. But, people are busy, and so that doesn't always work out. So we have a lot of solutions for that problem. Number 9, I've heard that the owner's title insurance policy now includes survey coverage, even if the buyer didn't have a survey performed. So why would my buyer still get a survey? Well, that type of policy is called an enhanced owner's policy, and it does have some types of survey coverage, but they are, some of them, subject to deductibles, and there's caps on liability. And I think also, as a general rule, a buyer would like to know what issues they have before they become the owner of the property. So even if you make a claim on your title insurance policy, and even if some of the cost of that survey issue is covered, it might not cover all of the costs, and you might have to pay a $25,000 or $5,000 deductible in order for the coverage to even kick in. So, Ganek as a firm, we recommend that all of our buyers who are buying a single family property, or certainly a commercial transaction that they're usually required by the lender, that they obtain a survey as part of the closing. And sometimes the seller has a survey and we can take a look at that, but we really need you to get that plat of survey to us ahead of time so that we can make a recommendation as to whether a new survey is needed or not. Number 10, the seller has an outstanding balance to the homeowners association. He disputes those charges and believes the HOA is treating him unfairly. What are his options? Well, unfortunately, it's to get the closing letter revised prior to closing, because the law firm, title insurance, we are required to follow the letter that's issued by the association. And usually that's by a management company on their behalf. And sometimes as a courtesy, like, something simple, like, we're closing on October 5th today, and the HOA fees are due on the 5th, and the seller set up for automatic draft, and the auto draft pulled that payment on the 3rd, but we ordered our letter a week ago and we got it last Friday. So our letter is now stale. I'm happy to hold the October association fee until we have time to get the HOA letter updated. But if you're having a dispute, like, the special assessment doesn't apply to me because I have this type of unit and that unit isn't one of the ones subject to the special assessment. That's not something that I can stick my neck out and put the buyer and the buyer's lender, if the transaction's financed, at risk, because once the buyer becomes the owner, then that lien is going to attach to their unit. So we have to rely on the letter, and we'll, again, the sooner there's a dialogue, the sooner we can try and get something resolved. The law firm's happy to try and help the seller communicate, get the right persons at the association involved. So we're happy to help, but we can't just ignore the letter, and we can't hold money, indefinitely. So it really depends on the circumstances. Number 11, my client is selling his property and would like to do a tax-free exchange. Can you tell me how that works? So that's sometimes called a 1031 exchange. So if your seller is selling an investment property and they plan to roll the money from the sale of one property into the purchase of a new one, that's called the replacement property. And there are 1031 exchange companies out there that will assist with that. So they're an additional party to our transaction. So they act as the title, they are the intermediary. So the money from closing, rather than going to the seller, goes to the intermediary. The intermediary holds the money, and then later when the seller buys their what's called the replacement property, the money from the intermediary goes to the next closing. And I've actually closed a bunch of these lately. So since the market, we've been in a rising market, and a lot of sellers think now's the time to sell. They can replace it with a different property, maybe in a different location that they think is still got some appreciation coming, or maybe they switch it to a different. They could go from a single family residence that's a rental property into an apartment building or something like that. So as long as it's like kind exchange, you have to go real estate to real estate or auto to auto. So yeah, there are companies, and certainly we can at the firm we can put you in touch with some of those intermediaries if your party needs a referral. And then the last one is, we are closing on the 16th of the month. Should my seller pay his current month's mortgage payment? Well, the 16th, we picked that date deliberately because most mortgages, the payment is due on the 1st. There is a 15-day grace period. So technically, the last date that the seller could pay their mortgage and not incur a late fee would be on the 16th. And our closing is on the 16th. So our payoff isn't probably going to get to the lender until it won't be posted until the 17th. So they're looking at a late fee. So in that scenario, we'd be fine with the seller going ahead and paying their, in this case, let's say their October mortgage payment. We just need you to let us know that that has taken place so that we can hopefully order, if we have already received the payoff statement from the lender, we would want to obtain an updated payoff statement. What usually happens is that we get to the closing, we're down to the last, 48, 72 hours. We send out a preliminary settlement statement. We typically send those to the agents first. We like you to have the opportunity to review that before it goes to your client. We can kind of clean it up. If the commission is, we don't have the commission agreement, agent will send us the commission agreement. This one's going to be a 5% commission instead of 6%, 3% to the buyer's agent, 2% to the seller's agent. We'll make those changes and then we'll get it out. And then maybe, seller's busy, not paying attention. The night before the closing, they look at the mortgage and they say, this is wrong. And that's because it's not really wrong. It's based on outdated information. So sometimes we can order a payoff update at the closing table. Some of those come in, we enter some data on the phone and we get the fax 15 minutes later, so we're good. But some of those take a couple days to update. So the sooner we know about that the seller has paid their mortgage, the sooner we can look at our statement and say, oh yeah, look like our mortgage payoff that we have in our file shows the seller due for October 1st. We're being told that the seller has already made the October 1st payment. We'll go ahead and order an update, and we'll be able to revise our settlement statement before everybody is seated at the table. So ultimately, we just want closings to go smoothly. And really, all of this that I've been talking about today is a matter of communication. Communication is key. So as long as you let us know what's going on with your transaction, as long as you are responsive to emails, get your clients to fill out our forms promptly, then that is going to lead to a smooth closing. And that's our goal. You know, we want your clients to get in and out of the closing in an hour or less is always my goal. So a quick last couple things is in terms of ordering title with Ganek, we make it very simple for you guys. You have an email address that you can use that's read by several attorneys, several staff members. That is closeph@Ganek PC. So that's close, like close the transaction, PH for PalmerHouse at Ganek PC, CLOSEPH@Ganek, GANEK, PC.com. So that's the email address. You can also go on our website and order a title there. And some of the questions that we're going to ask you are, in which office would you like to close, and which attorney would you prefer to work with? So please, if you haven't closed with us before, we would certainly welcome the opportunity. We have really done a lot with improving, our systems and the forms and the communication process. We alert you to things that are happening in your file before you even think to ask the question. So if you haven't closed with us in a while, please give us a try again. If you close with us regularly, we thank you for your business. We are so grateful for the relationship with PalmerHouse. Like I said, you guys are one of the most important relationships that we have, and we really value you and the company and now HomeSmart as well. So thanks very much.
Thank you very much.
Thank you so much.
Any last questions from anyone?
I'm
not seeing anything in the chat.
No, I don't think so. And I definitely put the website and the email address and everything in there too, so people can copy that if they would like to.
Thank you, Caitlin. Appreciate it.
You're welcome. It was good seeing everybody.
Right.
Thank you. Have a good day.
All right. Thanks, everybody.
Bye-bye.
Bye-bye.